Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukkara. On 14/4/2025, Ambedkar Jayanti Day, Honorable Justice retired Rohington Nariman, he released a book called as The Basic Structure Doctrine Dash Protector of Constitutional Integrity. And while releasing the book, in the opening remarks, he has given a categorical explanation as to why he has to write the entire book, the necessity, all these things he has explained very clearly. And whenever the basic structure doctrine comes into picture, you have to remember the very famous Kesavananda Bharati case. His Holiness Sadguru Kesavananda Bharati versus State of Kerala, 1973 case. What is basic structure? What is rule of law? Why the necessity is there? And how the judiciary also tried to actually revisit the same. All these things he has discussed in detail. Please, if you have fine time, see the YouTube channel in which Justice Rohington Nariman's lecture is there. Right. Then, if he said, if the basic structure doctrine withers away or goes away, God only should help this country. And he started a speech with another incident. Actually, he released a book on 13/4 and he has cited another instance, that is on 13/4/1919, 14th in Ambedkar Jayanti, 13/4/1919, General Dyer, he ordered or he killed so many persons, so many innocent citizens in Jallianwala Bagh near Amritsar. And if the same repeats, what will happen? So that is what we are going to discuss. ఎందుకంటే ఈ బేసిక్ స్ట్రక్చర్ డాక్ట్రిన్ జ్యుడిషియల్ రివ్యూ లేకుండా ఉంటే ఎస్ ద గవర్నమెంట్ కెన్ డూ ఎనీథింగ్, దే కెన్ కిల్ ద పీపుల్. అందుకని దానికి వ్యతిరేకంగా ఆయన చేసుకొచ్చారు. ఎనివే వెరీ వెన్ ఎవర్ వీ క్వశ్చన్ ది బేసిక్ స్ట్రక్చర్, Kesavananda Bharati case, you remember, 6/7, razor thin majority, Patanjali Shastri. So the person who dissented is H.R. Khanna. He said it is only limited obligation or implied limitation. Justice Nariman said it is inherent limitation, the word would have been better. And the discussions between Attorney General and H.M. Sirwai and all these things he has mentioned in this book. Now coming to Kesavananda Bharati case, we have started with Shankari Prasad versus State of Bihar, then went to I.C. Golaknath case, then came back to Kesavananda Bharati case, where the amendment is also a law. It can be, the basis, constitution can be amended because of the necessity. But the majority said, yes, it can be done, but the basic structure should not be disturbed. What is basic structure? Later we came to know in the number of cases like rule of law, basic structure, rule of law, judicial review. All these things are basic structures. Right. So actually this was not appreciated by the later section of the judicial officers. Right. Then came 1975, Indira Gandhi versus Raj Narain case, where the justice clearly, 4 judges, they relied upon Kesavananda Bharati case and they have done away with the 39th amendment. Because at that time, Madam Indira Gandhi, Prime Minister of India, was accused of using the so-called election election fraud. So therefore, she brought an amendment to Article 329A, which says that election offences cannot be dealt with or cannot be reviewed by the court. They have put a ban, but it is against to basic structure. This is what is stated by the next judges bench, constitution bench. Against this, at the time, Chief Justice Ray, A.N. Ray, I think. So he was actually literally forced, or he constituted another bench consisting of junior judges. Ultimately, he started the discussion stating that this has come up because of the allegation by one Palkiwala's client. Then Palkiwala said, no, I did not raise any objection on my client, sir, will not do it because we are not against to the basic structure doctrine. We are not against to Kesavananda Bharati judgment. And then rule of law. Ultimately, he said it is from Tamil Nadu. So Swaminathan Govindan or Govinda Swaminathan, he immediately said, no, we did not do it. Ultimately, there was an internal revolt among the judges. H.C. Ray next day came and he said, I am dissolving the bench. This basic structure doctrine was once again utilized in Minerva Mills case. Minerva Mills versus Union of India, 1977. There also, please remember, the 42nd Amendment has been actually challenged and it was struck down as against to the so-called against to the basic structure doctrine. So friends, remember, if you go through the book, it's okay. LexisNexis, they have published the book. And in this connection, he has discussed mainly focused on three important cases. One is Kesavananda Bharati, second is Indira Gandhi versus Nariman case, and third one is Minerva Mills versus Union of India case. Very, very important case laws. Besides Shankar Prasad, that Singh, I am not able to remember, I.C. Golaknath, all these cases. So they are all very landmark judgments. You have to remember them, you have to repeat them. That's why, once again, even though there is enough time, 7 minutes is over, yet still I am continuing this class because of the importance of His Holiness Kesavananda Bharati case. Basic structure doctrine, rule of law. Otherwise, what will happen? Suppose if General Dyer orders killing a person, if there is no review, what will happen? Government will say, yes, he has done it correct. So for that purpose only, basic structure doctrine is 100% necessary. Rule of law is 100% necessary. Judicial review necessary. Okay. With this, I am concluding. Thank you very much.